Welcome back, everybody. It's Michael Leveris from JurisQ.com, where we answer legal FAQs on different practice areas in law and in different states. Today, we have with us back Alla Kurolapnik, a divorce attorney that is a big proponent of mediation using mediators in a divorce. And Alla, welcome back. Thank you for your time.
Thank you, Michael. Thank you for having me.
Alla, prenups. We discussed prenups before, how they relate to in mediation, but today let's talk about prenups that are too prohibitive, meaning one party put in divorce agreement, I'm sorry, prenup agreement, something that is so extraordinary that no court is going to accept and validate. So let's talk about that. What have you seen out there with prenups that are too prohibitive?
I mean, look, depending upon who I'm representing, whether it's the moneyed spouse or the non-moneyed spouse, my preference is always to advise the moneyed spouse so they can, because you have to really understand the nature of the prenup, right? And, this encounters, wide discussion. So generally, courts favor contracts that are put together by two parties, because they say if you guys have agreed to it and there's nothing illegal here, then who are we to undo what the two of you have decided? So long as it meets the criteria of the legalities that we want and it's legal in the state of New York, then we don't want to touch it. This is your agreement, right? However, there's been a change, or the trend has been to deviate from that in a sense, because if the courts find that a contract or an agreement was signed under duress, that if it's unconscionable or it's based on fraud, then those kind of contracts in themselves tend to be set aside or vacated. In other words, what you've agreed to it is not sufficient. So the first piece of advice I have with respect to these prenups or postnups is be very transparent, because if there's an ounce of fraud anywhere in here, 15 years later, when I'm not involved in your life, because I'm going to be retired in Boca with my kids, somebody else is going to be looking at this and saying, okay, what am I looking at? What happened here? And then somebody else is recreating that story. And if there's full transparency between the parties, then fraud is not an element that would have much substance in a person alleging substantively that kind of claim. Okay. Same thing goes for duress, right? And the big seminal case that, kind of changed the way, sort of, one of the big ones that, first said, look, we understand this is an agreement between the parties, but it was done under such duress that we can't possibly consider this to be a valid agreement. In that particular case, the parties have been dating for a very long time. And, the woman got pregnant. They weren't married yet. They wanted to, do the prenup before she gave birth. And he literally had her sign the prenup, I think, like in the hospital bed as she was, getting ready for labor, or like on the 8th month, right? Where she really, she was just worn down. She was concerned about the baby. She was concerned about a number of other things. And in that particular case, the court found that an agreement like that is just signed under duress. So make sure you have all the elements, right, when you're working on a prenup that address that. In other words, with respect to duress, I always say two things. You both need to have lawyers, right? One lawyer cannot do this for you. And especially if there's one party that has a lot more assets than the other, I highly recommend that the other party gets an attorney, because otherwise you want to be able to avoid a situation in years down the line where it gives somebody the ability to challenge that agreement. Okay. And so the way to do it is to protect your client. And the best way to do that is to advise them. If there's going to be first is transparency, then there's the issue of duress, right? So make sure that everybody is represented by counsel. Make sure that you have a client that doesn't speak English, that you're getting that agreement translated in the other language, and you're attaching the translation copy, certified copy, to the English or English agreement, so that there's no misunderstanding about who understood what. You have no idea how many times I get the phone calls of, I didn't know what I was signing, I didn't speak English very well, and I wasn't represented by a counsel. Can we set it aside? Well, you have claim to do that, but again, the mere fact alone that, let's say, you're not represented by counsel, I don't know if that's enough. Like, what are the circumstances surrounding it? It may not be enough to set it aside. So you better make sure that you're protected in all those things. So that's the second thing I recommend. And the third and most important thing is you have to make sure that the agreement is not unconscionable, right? So the way the law looks at it, and again, there's a slew of case law that says what is unconscionability, right? And the real factor is, was it okay when you entered it, but when you now enforce it, it's completely unconscionable. In other words, and I'll give you like just a made up scenario. So you have the scenario where the woman was a CFO of a big company, making a lot of money, right? Stops working, becomes a home parent, forgoes her career to advance the career of her spouse, has children, does all that. So at the time you entered the agreement, and she may have waived all of her equitable distribution, all of her maintenance, it may have been a doable thing for her because she's like, look, I'm a CFO, it's fine. But 20 years later, she's been a stay-at-home mom. The enforceability of that is not so much in her cards, because whatever assets she may have accumulated prior to the marriage may now not be sufficient to cover her going forward. So again, the real test is whether or not it's unconscionable at the time that the agreement is enforced, right? So my advice is to clients who tell me, I don't want my spouse to have anything. I said, well, let's figure this out. I said, because if I were their lawyer and I read an agreement that was very prohibitive, and they came to me in 15 years, I would say, you have a really good shot at setting this thing aside. So why don't we try to take it? The idea is for you not to be in that predicament. So you have to think in that frame of mind, that you are fair enough in the agreement that you can then say, if your spouse comes back and says, I want to challenge this agreement, you're then in a position to say, look, there's definitely no fraud. We were very transparent. Everybody's represented by counsel. Your rights were explained to you. You voluntarily entered into this agreement. We've discussed the possibilities. I'm giving you X amount or Y amount, or I'm allowing you to do this and this and this and this, because this is what we contemplated, because we knew you were going to take a step back. And then you have better footing to say this agreement is valid. So that's kind of what I advise all of my clients, because the idea is to protect yourself against litigation in the future.
Exactly. See, this is the role of a proper seasoned attorney, to prevision what could be the outcomes many, many years down the road. And how do you get that vision? From prior experience, right? Because Alla, you have seen out there what works in the prenup, what does not work, what actually shocks the conscience of a court, that the judge is going to say, no, I don't care what you guys agreed 10 years ago. This is completely unfair to the other spouse. And this is why I think it's important to, like you said, each party to have their own attorney and consult an attorney, a divorce attorney, before you even contemplate drafting a prenup agreement, or if you're presented with one, to review what it says. Alla, thank you so much for your time. We appreciate it. Thank you for educating us and the public on the nuances of a divorce and how mediation plays in a divorce. And if anybody has any questions, please feel free to reach out at the phone number on the bottom of the screen to Alla Kurolapnik.
Thank you so much.
And we're going to come back with a very interesting topic. We're going to talk about sharks, not the ones that are in the ocean, but are still very dangerous and predatory attorney sharks, should you hire one. Stay tuned.